this point in time, we are prepared to move forward with closing arguments. So we will be starting with the state and then moving over to the defense. The state will have an opportunity to speak with you twice. It is not that the state gets more time. Each side gets the same amount of time to conduct their closing argument, but it is only the state that you may hear from on 2 occasions during closing argument. You don't have your notepads with you because, again, closing arguments are not evidence, so they will be provided to you at your deliberations. At this point in time, is the state ready to proceed?
It is, Your Honor.
All right, Attorney Stein, you may proceed.
Good morning, ladies and gentlemen of the jury. You have patiently listened to the evidence in this case, and you've made personal sacrifices in your own lives in fulfillment of this important civic function. I know all the parties connected to this matter thank you for the careful attention that you've brought to your role here in this matter. We acknowledge it has been difficult on you at times. We are now at the part of the proceedings that are called the closing arguments, and this is where the attorneys will summarize our respective cases for you. Following our remarks, Judge Murphy will provide you with her instructions and the rules of law. But please keep in mind that we all have separate functions here. You are the judges of the facts. Only you decide what the facts of this case are. Attorney Gavin and I were advocates for our respective positions. Judge Murphy is in control of the proceedings, and she will provide you with the law that is pertinent to this case. She will instruct you to apply the facts as you determine them to be, to the laws as she gives it to you. Judge Murphy will define for you what is evidence in a case and what you may consider. And amongst the things that she will tell you is you can consider the exhibits that have been introduced to you by the parties and the testimony of the witnesses that took the stand during the case. But I ask you to recall, each one of you during your voir dire process, during the jury selection process, I asked each one of you, just because someone swears an oath to tell the truth, does that automatically mean to you that you will always get the truth? To that end, Judge Murphy is going to instruct you, caution you, and advise you that in deciding what facts to consider from the testimony of any witness, you may believe some of what that witness says, all of what they say, or nothing that they say, based upon the following criteria. How well was the witness able to recall the details and testify to them? What was the witness's manner while they were testifying to you? Did the witness have an interest in the outcome of the case or any bias, one side or another? How reasonable was the witness's testimony in light of all the other evidence in the case? And was that person's testimony contradicted by what that person said or did at another time, or by any other witness, or by any other evidence in the case? Judge Murphy will instruct you that if you think a witness has deliberately testified falsely in some respect, you should carefully consider whether you should rely on anything that witness said. So in other words, evidence is not just anything that is spoken from the witness stand. It must be credible. Judge Murphy will also tell you what is not evidence in a case such as this. First and foremost, she is going to tell you that these arguments, right now, the arguments of the lawyers, this is not evidence. As I mentioned earlier, the lawyers are advocates for our respective positions, and therefore we are inherently biased. Judge Murphy will instruct you that these arguments, or that the questions that are asked by the lawyers during the course of the case, that they're just argument. These arguments should point you to credible evidence in the case that supports the argument. Because argument that is not supported by credible evidence is just that. It is argument that is unsupported by the evidence. Because if it's not credible, then it's not evidence. Judge Murphy is going to tell you that you may not go outside the evidence, not to resort to guesswork or conjecture or speculation. She will tell you that while you may entertain an inference that a lawyer asks you to make, that inference must be drawn from credible evidence, and it must be reasonable and logical. It has to be reasonable and logical inference that relates to credible evidence. Because if not, then it's simply an inference unsupported by evidence. Now, in a few moments, the defendant's lawyer is going to come up here and he's going to tell you a number of things. He's going to tell you that the state has failed to prove its case to you because of two diametrically opposed reasons. He's going to tell you that the defendant didn't do this. Mr. Morales testified that home invaders killed Christine Holloway, left the only eyewitness to a brutal killing alive for some inexplicable reason, and then kidnapped Vanessa Morales. He is then going to suggest to you that if you do not believe the sworn testimony of his client, where his client raised his right hand in sworn oath to you, where he looked you right in the eye and flat out told you he was not responsible for this crime, then clearly he was on PCP, that this was a PCP-induced delusion, and that 5.5 years later, he still believes that there were home invaders that were responsible for this brutal crime. He is going to say to you, who calls 911 before killing somebody? He is going to point you to the 911 call and suggest to you that the tape supports the inference that his client was high on PCP. He is going to suggest to you that the brutality of the crime itself is evidence of aggressive behavior caused by acute PCP intoxication. He is going to suggest to you that there is no motive to otherwise cause such an attack. But remember, this is arguments of the defendant's lawyer. This is not evidence. Once Attorney Gavin lays out these inconsistent and diametrically opposed theories, I will come back and explain to you why the credible evidence in the case does not support the inferences that he is asking you to make, and why the only conclusion that you can possibly make from the credible evidence is that on December the 1st of 2019, sometime after 2 a.m. and before 6 a.m., Jose Morales intentionally caused the death of Christine Holloway by striking her in the head not less than 8 times with an instrument that caused blunt force trauma, thereby causing her death, and thereafter spending the next 36 plus hours systematically cleaning the crime scene in an attempt to erase all evidence and thereby existence of Christine Holloway until interrupted by the police beyond all reasonable doubt. I look forward to speaking with you again after Attorney Gavin's comments. Thank you, Your Honor.
Thank you, Attorney Gavin.
Thank you, Ron. Good morning, everyone. I guess I shouldn't have spent Easter Day at my kitchen table figuring out what I was going to say to you today, because the state has it all framed out for you already. But that's really not the case. I want to thank you for your service. I want to thank you for your attention. And I know that your lives have been interrupted, your family lives, your work lives, your everyday affairs, to be with us today. And I appreciate your attention and dedication. I think we're about 2 weeks ahead of schedule, so hopefully that gives you a little buffer. In the most difficult of circumstances, I tried my best to fairly and accurately provide you with all of the information for your consideration regarding the events of December 2019, the good and the bad. The state offered almost 200 exhibits in this case, and as you know, I didn't object to any of them. Let the jury see all of the exhibits in the case. I wanted you to have all the evidence to make an informed decision here. And as the state said, this is my only opportunity to speak to you, and I welcome it. As prosecutors, we get trained and prosecutors in this case are trained to reserve their comments until the latter portion or the rebuttal portion of their closing argument. That's because the state has the burden of proving the case, so they get to go twice. And that's what's going to happen in this case. And why are they trained in that regard? Well, the first is so that they can get up and say everything that I argue to you should be discounted and not taken into consideration. And the second is how we handle our everyday affairs. The state likes to get the last word in. That's just how our system works because they have the burden of proving their case and we don't have the burden of proving everything. So, what do we know after months of jury selection and 9 days of evidence? We know the state has not proven a murder case against Jose Morales. In February and March, when we selected the jury, I asked each and every one of you to bring your good common sense to court with you, and you promised me that you would. And now I'm going to ask you to use that good common sense and apply it in your deliberations. The benefit that you're going to have now that we didn't have during jury selection is we're going to have the opportunity for the jury to hear the applicable law of the state of Connecticut as given to you by Judge Murphy. And I'm going to ask you to listen to her instructions and respectfully to follow her instructions in regard to the evidence that was presented to you. Please always remember there are two principles of our judicial system that are the backbone of the system. The first is Jose Morales, as he sits here, is presumed to be innocent. Despite having all of the trial and all the evidence go in here, he's presumed to be innocent. And the second is that the state has the burden of proving these charges beyond a reasonable doubt, which they have not done, and we're going to discuss reasonable doubt in a second. Trust me, if you weren't reasonable people, you wouldn't be sitting in the jury box today. I'm confident that you all have good reason and you brought it with you and you applied it as you listened to the evidence. We have faith in you. Please remember that your doubts do not have to be unanimous. And what that means is your reasonable doubts in regard to what occurred back in December of 2019 can come from any different areas, and I make some suggestions to you. Jurors could say, I have a reasonable doubt about what actually happened on Sunday, December 1st, 2019. Totally appropriate and fair. Others could say, I have a reasonable doubt because the state has not proven its case at that high standard of proof beyond a reasonable doubt. Others could say, who calls 911 before committing a homicide? There's no evidence there was any problem between Christine Holloway and Jose Morales on that date. Others could say admitted PCP use causes me to believe that Jose Morales could not have formed the specific intent that is required to prove a murder case. These are just some of the examples, and there are many other ways and many other reasons. I'm going to ask you specifically to consider these facts. Chelsea, if you wouldn't mind. This is the 911 call. Use your good common sense. Who calls 911 before committing a homicide? No one. And don't forget, that's Christine Holloway's voice in the background on the call. Christine was there. I want you to please respectfully ask yourself, why did the state try to hide the issue of PCP in this case? Why? PCP use clearly happened. Morales testified in regard to going to Bridgeport with Rodriguez, getting the PCP, having 2 bags of PCP with him, and his continued ingestion over the weekend. Morales had ingested PCP on December 1st. You can hear it in his voice. He was barely able to speak. Remember the testimony of Officer Jacqueline Tresser, who was assigned, that was the police officer that was assigned as the dispatcher. That's whose voice you hear. What do you hear? Her testimony. She said, voice slurred. No screaming or yelling between Jose and Christine. No physical violence, no confrontation whatsoever. Ask yourself, why didn't you hear from Detective Stephen Adcox, the lead investigator in this case? It wasn't presented here for you.
Your Honor, I'm going to object with regard to this. This is not appropriate argument.
All right.
With regard to.
Let's move on in the argument. We'll reserve the objection. Counsel.
Thank you. As you know, Morales was interviewed and his interviews were recorded December 3rd, December 12th, December 17th, December 23rd, January 9th, January 21st. As Morales' memory came back from the use of PCP, he told the police what happened. This is not some manufactured story from 5 years later. This was contemporaneous with his arrest and the investigation in this case. The police even sent his mother, Lydia De Jesus, into Cheshire Correction, as you recall, on December 9th, and it was recorded as he was talking to his mom. Morales' story is completely consistent from December of 2019 right up through and today. As soon as Morales' PCP clouded memory came back, he told the police what happened. What's the supporting evidence of that? The 911 call, where clearly he's impaired. Now, how about the surveillance video showing the home intruders leaving the area of Myrtle Avenue, which we played for you? That was Exhibit F, G, and H, where Morales indicated he went to the front door, he looked outside, he saw the vehicle coming down Myrtle Avenue, and the second assailant got in the car, and it's on video. You can't manufacture that. That's there. Did the state introduce that? No. Why wasn't it introduced? Because it didn't fit their theory that this was an open and shut case, which it isn't. Morales took the stand, didn't have to testify, and owned everything that he did. And by the way, after 5+ years and all of these investigators and all of these police officers and the FBI and the New Haven police and all the other agencies, you know what you don't have? The state never produced a murder weapon for you. Not once. You can take that into consideration as well. There's another reason why the state wanted to hide the PCP intoxication evidence from you. That's because of what Judge Murphy is going to instruct you regarding the law of the state of Connecticut. And from this instruction, the jury can't vary. In any prosecution for an offense, evidence of intoxication, so the first thing you have to say is, what is intoxication? A substantial disturbance of mental or physical capabilities resulting from the introduction of substances into the body. That's the PCP. It can apply to alcohol. It can apply to any number of drugs, but in this case it has to do with PCP. That evidence may be offered to negate an element of the crime charged. In a murder case, the state has to show there was specific intent to kill. It's not here. Specific intent to kill is, I hate Ed Gavin, I'm going to shoot Ed Gavin, I want to kill Ed Gavin. There is no evidence of specific intent brought to you by the state in this case? Absolutely none, which is required in order to successfully prove the charge of murder. Much to the state's discomfort, Judge Murphy's going to instruct you, if you find the defendant was intoxicated, you may take that fact into consideration in determining whether a defendant was in such a state of intoxication as to be incapable of forming the required specific intent, which is a necessary element of the crime. That's from the court. Listen to her instruction. I believe the judge is going to provide you with a written copy of her instruction. You'll find it right in there under the intoxication section. In regard to specific intent, there's an old trick that prosecutors use. And I don't know what Mr. Stein's going to do, but in the past, this is the way that prosecutors are taught. If there's no evidence of specific intent, which is not in this case, then what you do is you argue to the jury that the number of gunshots, or if it's a stabbing, or if it's an assault with a bat, show the jury the specific intent. That is not the case. It's a way to go ahead and hide the fact that you can't show the specific intent. The evidence doesn't support it. The state still has to show the defendant intended to achieve a specific result, and they just didn't do it in this case. The evidence in this case only shows a lack of intent. What do you know from the evidence? The day before Thanksgiving, Wednesday, everyone's over in New Haven at Morales' parents' house. They're doing Christmas decorations. They sleep over that night. What happens the next day? The next day is Thanksgiving. We just had Easter yesterday. It was Thanksgiving. It's a joyous time. What do? They go to Bridgeport. You know that from the CAST report showing the cell tower tracking, okay? They go to Bridgeport. They spend time with Christine's family. They come back to New Haven. They have dinner with the Morales family at that time. Relatives are over. It's a joyous occasion. No problems. None. What happens the following day, on Friday? They go to Barbarino and buy a new car. It's a happy, fun, joyous occasion. 5 hours they're at Barbarino. Saturday, Jose Morales, Christine are in Ansonia at 6.5 Myrtle Avenue. No problems, no issues, no screaming, no yelling, no fighting, nothing. No specific intent. And then you hear, which we just played, the 911 call. And you don't hear any fighting or arguing there. You know, what's so popular in these cases is the reliance on forensic evidence. My bride of 40 years watches these crime shows over and over, and she tells me it always comes down to forensic evidence. What's the forensic evidence that was offered to you for your consideration here? Number one, there's no evidence of Jose Morales' DNA under Christine Holloway's fingernails. If this was this brutal murder committed by Jose Morales that the state alleged, you would see that evidence. We had the benefit of the lab. We had the two examiners of the lab, eminently qualified people, super smart people. And you know what? The reality is that there was no evidence of Jose Morales, of his DNA, under Christine Holloway's fingernails. And you can go back and we put the forensic reports in for you to go ahead and take a look at that. That's the reality of life. You would expect to find that. Then you have to go back and you have to say, well, what is going on here from the evidence that was submitted by the state? Well, the first thing that I think you would do is, because you have all that data, we introduced everything without objection, is Christine Holloway's cell phone. You see that Christine Holloway's cell phone calls the Morales cell phone on the morning of September 1st. Dave Carney was the fellow from the FBI, the special agent from the FBI, did a great job on that CAST report showing you day by day the transmissions and where the cell phones were binging off the towers. I thought he did a very, very good job. And you can even see from his analysis that on Sunday the 1st, you see Christine's cell phone binging off another tower in New Haven, different from Morales. And the real kicker here is, the real issue here is, what do you see in regard to Monday, December 2nd? You saw it in evidence here over and over. Christine's cell phone is binging off of the towers in Naugatuck when you know Morales is in New Haven. His cell phone has him down in New Haven, and the second to last page of the CAS report has that big red umbrella all over Naugatuck. That's where Christine's cell phone was. How about the other forensic science evidence? Morales testified to every single piece of it. Going to the donation bins. He told you he did that. Going to the Shell gas station, which is on the video. He told you that was him. The camera picking up from Maria's hair design. He acknowledged that was him in the car that was there. Going past the Ansonia Police Department building on Elm Street. That was him. He was there. He testified to that. The entire video montage that the state introduced, that I played for him when he took the stand, what did he tell you? That was me. Yep, that's me. 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 The fact that Morales readily admitted cleaning up does not mean that he committed the homicide. Apples and oranges, totally separate issues. In fact, I'm going to call on you to please, again, use your good common sense here. Does it make any sense to commit a homicide? Just think about this. Commit a homicide and then go ahead and put the crime scene evidence in a donation bin, by definition, where it's going to be found. Does that make any sense to you at all? No, it doesn't. Remember the testimony of Dr. Frazier. And by the way, did you hear the state call an expert to contest the testimony of Dr. Frazier? No. You know why? There was nothing to contest. What did Dr. Frazier tell you? Number one, PCP has been around since the 40s. Number two, PCP amnesia is real. It happens when you ingest PCP. Sometimes memory comes back. Sometimes it doesn't come back. PCP can last in the system for over a week. What did Morales do? What's the evidence show you what he did? As his memory is coming back, he's constantly in contact with the police to provide a voluntary statement to the police that's recorded. He's under no obligation to talk to the police, but he does. He goes in there. He talks to them on the 3rd. He talks to them on December 12th. He talks to them on December 17th. He talks to them on December 23rd. He talks to them on January 9th. He talks to them on January 21st. And what does he say? He says, this is coming back to me, and as it's coming back to me, he's providing the evidence to the police department. It's not like he made up some story all of a sudden. That's just not what happened, ladies and gentlemen of the jury. I appreciate the opportunity of having a chance to speak to you. Please, if it doesn't add up, and in this case, the one thing that's clear, it doesn't add up, then you have a basis for a reasonable doubt. And if you have a basis for a reasonable doubt, your obligation of a juror is to go ahead and render a verdict of not guilty. Please listen to Judge Murphy's instructions. It's not my instructions. It's the court's instructions in regard to the applicable law here. And it doesn't matter from juror to juror where your doubt comes. It doesn't matter if it's because of PCP use or because of inconsistent statements or the forensic evidence or the 911 call. All 9 days worth of evidence, you can consider any and all of it. Use only the evidence presented to you in this courtroom. Use your good common sense and render the fair, just, and reasonable verdict of not guilty to the offense of murder. I thank you for your time. Thank you.
Certainly.
I'm ready to proceed, Your Honor. Thank you.
All right, very good. You may proceed.
And there, ladies and gentlemen, you have it. It's not normally my habit to chase the comments of what the defense asks in something like this, but I feel compelled to respond to some of them. The reference to Stephen Adcox, why the state didn't call. You know, I'm fascinated by it any time I hear an argument like that because neither party owns witnesses. Any party has got the right to call any witness they want to put that witness in front of you. Did you hear the defendant call Stephen Adcox as a witness? Or for that matter, Hector Rodriguez or any of the other witnesses that could corroborate what Mr. Morales put in front of you? The videotape of the real killers, we've heard about the real killers from Mr. Morales in this particular case. I'll leave that to you to decide the value of that videotape. What the defendant said to Stephen Adcox at any point in time, there's no evidence in this case. Mr. Morales didn't talk about the details. So that's argument from Attorney Gavin, unsupported by any evidence, because you know nothing about what was supposedly said at any of these subsequent statements. The forensic evidence, right? When I hear arguments about forensic evidence like this, right? So first he asks you to assume that because Christine Holloway did not have the defendant's DNAs under her fingernails, that means something. Well, what does it mean? Does it mean that she never saw the first blow coming? She wasn't in a position to defend herself or scratch him to get his DNA under her fingernails? And think for a second if her DNA, or rather if his DNA was under her fingernails, what would the defense argument be then? Of course his DNA is there. They're in a relationship together. They're a couple. You would expect to find his DNA there. So that type of an argument is completely, I submit to you, without value in a case like this. But it's a distraction that he wants you to focus on. I submit to you, the judge will tell you that you are the judges of the facts, your memory of the facts. And if you have any doubts about the facts, you can ask the judge to replay any portion of any witness's testimony for you. Because without going through point by point, Attorney Gavin's just flat wrong on the cash report on many different items. And his timing or his memory of what that report shows, I'm not going to even go there. I'm just going to suggest if it's not readily apparent to you when you look at the report, you can have any witness charged back to you with regard to that. So let's just talk then about what we've heard here. You have Attorney Gavin's alternate theories here. The defendant takes the stand. He swears this oath to tell the truth. He's led on a direct examination by his attorney. And I'm sorry, I'm just timing myself here. My time clock's not working. He stands, he takes an oath to tell the truth. He's led on a direct examination by his lawyer. and his lawyer, and he tells a story that seems to be unsupported by any credible evidence. Just so his lawyer can stand before you during the closing argument and ask you to draw an inference that his client was suffering from a PCP-induced delusion at the time of the murder, and now, 5.5 years later, he makes the claim that he is still suffering from that same delusion. But think about it for a second. He is asking you to believe his client, but just in case you don't, here's the backup theory. Does any of that make sense to you, let alone in a case such as this, would you be able to draw these reasonable inferences from the evidence? Before I get into why the credible evidence in this case should convince you beyond all reasonable doubt, let me touch on some of the further aspects of the law that Judge Murphy is going to instruct you on. It goes without saying that if my comments or Attorney Gavin's comments ever conflict with or misstate the law in any way, you should always follow Judge Murphy's instructions on the law. Attorney Gavin argued that his theories should raise to a reasonable doubt in your mind, but the court is going to define reasonable doubt for you. She was going to tell you that a doubt must be a real doubt. It must be based in the evidence or the lack of evidence, but it is not a doubt that is based in speculation or surmise or guesswork or conjecture, or a doubt simply because Attorney Gavin wants to raise a reasonable doubt. Because that is not reasonable doubt. But isn't that exactly what Attorney Gavin is asking you to do here? The court will tell you that proof beyond a reasonable doubt does not mean proof beyond all doubt. The law does not require absolute certainty on the part of the jury before reaching a verdict of guilty. Now, I want to talk to you about the offenses that Mr. Morales is charged with, starting first with the second count of that document, the charging information, which you will have with you during your deliberations. That's tampering with physical evidence. I'm not going to spend much time going over the testimony with you. Rather, I would suggest to each one of you that all of the elements that Judge Murphy will instruct you on with regard to this offense can be found directly in the defendant's testimony, where he told you how he cleaned the crime scene and disposed of physical evidence in the education bins and destroyed evidence in the garbage disposal. So let's get right to the crime of murder. Judge Murphy is going to tell you that in order to find the defendant guilty, that Jose Morales intended to cause the death of Christine Holloway, and acting with that intent, he caused her death. So let's talk about intent. Judge Murphy is going to tell you there is no particular length of time necessary for the defendant to have formulated this intent. In other words, intent can be created in an instant, such as when a person engages in a sudden rage. The intention does not have to be long-standing. It doesn't have to be festering spite or ill will over a long period of time. It is an intention that can be created in a moment's time. The judge will also tell you with regard to intent that it may be and is usually inferred from the circumstances of the crime. Attorney Gavin would have you believe that we go to school, prosecutor school, to learn the tricks. This is based in the law. Judge Murphy is going to give you this out of her own mouth as to how you may look at the circumstances of the crime, because no witness can come into court and testify that they looked into the defendant's mind and therein determined what the person's intent was. You can't get direct evidence through any other way. The court will tell you that by using circumstantial evidence, you may examine such things as the number of wounds, the location of the wounds on Christine Holloway's body, the type of instrument that was used to create those wounds. It's circumstantial evidence. It's logical. If I decide to hit somebody in the head multiple times versus smack them in the toe with the same instrument, does that not manifest the person's intent when you strike somebody in the head versus in the toe as to what your intent was when you brought each one of those blows down time after time? To infer intent is part of your responsibility with regarding to determine the facts of this case. And you are permitted to infer the intent by the methods that Judge Murphy will tell you. In this case, the state contends the defendant struck Christine Holloway in the head with not less than 8 times with a blunt instrument that created 1-inch round circles with a reasonable inference which a reasonable inference from that evidence conclude was a hammer. I would suggest to you that the evidence supports the inference that a person who strikes another person in the head with a hammer not less than 8 times intended to cause catastrophic injury and death. There is no other rational conclusion. This clearly manifests an intent to kill and not an intent to wound. The second element of the crime of murder is, did cause the death. And you heard the testimony of the medical examiners that Christine Holloway died of blunt force trauma as the result of these injuries. Attorney Gavin did not argue to you about the lesser included offenses, but ultimately the judge is going to instruct you in their request that you consider these lesser included offenses based solely on the self-serving statements of Mr. Morales that PCP was even involved in this case. You heard from no other witness, no other evidence that PCP is even involved in this case except from Mr. Morales. Attorney Gavin tries to bolster his alternative theory with the 911 call, Dr. Frazier and the CAS report, trying to get you to accept part of the defendant's story that fits Attorney Gavin's alternate theory, even though his client flat out disagrees with that alternate theory. Members of the jury, the credible evidence in this case should overwhelmingly convince you the defendant is guilty of murder. If you find that murder is proven, then the judge's instructions that will follow will tell you to disregard her instructions to you on the lesser included offenses. However, if all 12 of you unanimously agree that the defendant is not guilty of murder, then and only then can you consider any of the lesser included offenses that Judge Murphy is going to provide to you. You may not go to the lesser included offenses unless each and every one of you believe the defendant is not guilty of murder. You have to reach that one first. You cannot consider anything less unless you all unanimously agree that he is not guilty of murder. The defendant's lawyer argued to you that the basis for the reduction from murder to manslaughter is based upon the defendant's self-serving claim that he was intoxicated on PCP. Attorney Gavin argued to you that Jose Morales could not formulate the intent to commit murder due to that intoxication. Pay heed to the portion of Judge Murphy's instructions that if you deem the defendant to be intoxicated, the intoxication must be a substantial disturbance of mental and physical capabilities that effectively create an inability to formulate the intent necessary to commit murder. You may believe that the defendant, although intoxicated, was still capable of forming the specific intent. In that case, the defendant's responsibility is the same as if he were not intoxicated. It must be a substantial disturbance of physical and mental capabilities. So let's talk about what the credible evidence in this case shows you. The defendant would have you believe that everything in his world was bright and rosy. He talked about the wonderful holiday season he and his family were having at Thanksgiving time in 2019. But the reality for Christine Holloway was anything but that. Witnesses such as Rosie Clark and even Mr. Morales told you about Christine Holloway. Hardworking, church-going, dedicated, single mother. Mr. Morales told you he was unemployed, stressed, living with his elderly parents in their basement, together with his 2 other children, who his parents were also supporting. He acknowledged that he was a part-time parent and part-time partner to Christine and Vanessa. He denied being a controlling and jealous, abusive man. However, his text messages tell a different story. Please take the time to carefully go through them, because therein lies the snapshot into Mr. Morales' life and motives that could cause him to fly into a rage and kill Christine Holloway. Clearly, he controlled and scrutinized her. Where was she? How did she spend her money? She professed her love for him and told him about the beautiful future she envisioned for their blended family, while he demands proof that she actually canceled her gym membership. He then has the gall to tell you on cross-examination and then attempt to spin it that on the Friday morning following Thanksgiving, he went to the gym to inquire about his gym membership because he needed to get back in shape. He admitted to calling her a pig. He admitted that he would swear at her awful, nasty words. He admitted he didn't trust her. He admitted that he believed she was seeing other people. And no matter how much she reassured him or professed her love for him or sent videos of their child to him or assured him that God would see them through these challenging times, she was never good enough. He toyed with her emotions, telling her, "This stupid relationship is done." That's only days before Thanksgiving. This man would tell you stories of the weekend of Christine's death. Sure, he had 5.5 long years to think about it, to review all the police reports and all the evidence in this case, to draw his maps and diagrams of 6.5 Myrtle Ave. Interestingly enough, leaving Vanessa's crib out of the diagram for 6.5 Myrtle Ave. His direct, did it seem scripted? Did it seem rehearsed? Did you notice on direct how Mr. Morales accounted for his movements of this PCP-fueled weekend right down to the exact minute? Did you notice his demeanor? Did you find him to be flat, cold, matter of fact? Did he show any signs of emotion during the crime scene or autopsy photos? And this is where Judge Murphy's instructions on credibility come in. The court will tell you you may consider his demeanor on the stand while he is testifying and the manner in which he is testifying. I'm not going to take you through all the details that Jose Morales gave you regarding his claims that other people killed Christine Holloway and kidnapped Vanessa Morales. I will simply reiterate the court's instructions that if you think a witness has deliberately testified falsely in some respect, you should carefully consider whether you rely anything that that witness has to say to you. So let's be clear. The only reason that PCP is even in this case is because Jose Morales took the stand and self-servingly told you he smoked PCP. Was that a setup for this alternative theory provided by Attorney Gavin? There's no other witness, no other exhibit, no other evidence that corroborates, confirms, or supports the defendant's assertion that he was using PCP that weekend. Sure, Attorney Gavin points to you the CAST report in an attempt to bolster that theory. But all that report tells you is that the defendant's cell phone was tracked to the Bridgeport area. It doesn't tell you who he was with. It doesn't tell you what he did. Attorney Gavin points to the cell phone records and identifies Hector Morales. There's no evidence in this case that indicates where the defendant went, who he went with, or for what purpose other than Mr. Morales' self-serving statements. You would have to believe him to make inferences from the CAST report or the cell phone records as to why he went to Bridgeport and for what purpose. And can you believe him? Attorney Gavin would have you believe that the 911 call is evidence of his client's PCP intoxication to once again bolster his alternate theory. I submit to you that all you can infer from the 911 tape is that Mr. Morales is slurring. In order for you to infer that the slurring is from PCP, it would require you to find Mr. Morales credible from this self-serving testimony. And again, can you believe anything that he says? Judge Murphy's credibility instructions will advise you further that you may consider from any witness who comes before you to testify whether that witness has an interest in the outcome of this case as a factor for you to determine his credibility. I submit to you, who has the greatest interest in the outcome of this case? Once again, the only evidence of PCP in this case comes from the lips of Jose Morales. Jose Morales spent nearly 2 weeks following this crime denying he was even with Christine Holloway that weekend. He denied it to the Ansonia Police, the Connecticut State Police, the FBI, his own family. You saw it on the tape. Before finally introducing PCP into the conversation. Then the defense offers you Dr. Eric Frazier, a clinical psychologist, not a medical doctor, not a toxicologist. This is their expert on PCP. The court will instruct you that a person may testify as an expert before you if they have special knowledge or skill, experience, training, or education on the subject to which their testimony relates. I am not going to spend a lot of time on what Dr. Frazier said about his experience in the area of PCP. My cross of Dr. Frazier, together with his CV, which I put into evidence for you, I believe is all you need to know about Dr. Frazier's experience with PCP. Judge Murphy will instruct you that an expert's testimony is entitled to such weight as you find the expert's qualification in their field is entitled to receive. No such testimony is binding on you, and you may disregard it in whole or in part. It is not controlling upon your judgment. Dr. Frazier admitted he read several articles nearly a half-century old, combined it with his non-medical education and his 1 year of postgraduate clinical work from 20 years ago. And he told you all the horrible things that acute PCP intoxication does to a person for the tidy little sum of $10,000. I think he said that in his entire career, he has only seen one acute PCP intoxicated patient during his clinical time 20 years earlier. When instructing you on an expert's testimony, Judge Murphy will also remind you about the general instructions on witness credibility, because that also applies to experts. And one of those instructions enables you to consider a witness's bias and interest in your verdict. Does Dr. Frazier have a business interest in your verdict or a bias to one side or the other? That is for you to decide. Nevertheless, Dr. Frazier told you how acute PCP intoxication causes impaired cognitive ability. And Mr. Morales hopped right on during his subsequent testimony, telling you how everything goes dark, can't see, everything is blurred, can't stand or maintain balance, can't yell, can't scream as someone is killing your child's mother and carrying your child away. He told you how he becomes cognitively stuck. And that seems to fall right in line with what Dr. Frazier professes he read in those nearly half-century-old articles. However, a cognitive deficit-causing drug like PCP does not line up very well with the rest of the evidence in this case. Dr. Frazier told you the average half-life of PCP is 8 hours and even longer in higher doses. He told you that half-life is the point in time where the body has metabolized half the drug's potency. On cross-examination, I asked him to correlate cognitive function to executive function. I asked, you will recall, he agreed with me that executive function of the brain are those sets of cognitive process that help us self-regulate, plan, prioritize, and sustain efforts towards a goal. He then further agreed that key components of executive function would include working memory, that is, holding information temporarily in your mind so that you may work with it. Set shifting and cognitive flexibility, which is the mind's ability of adapting to changing demands and the ability to switch between tasks. I then asked him if signs of executive dysfunction would include difficulty with planning, organizing, and prioritizing tasks, challenges with time management and staying on track, trouble with task completion and following multi-step instructions, problems with focusing, concentration, and paying attention, struggles with motivation and initiating tasks, inflexible thinking and difficulty adapting to change. And Dr. Frazier agreed with me that all of these things may be signs of executive dysfunction. And ladies and gentlemen of the jury, this is where the whole PCP story falls completely apart. Think about what this man did after this horrific act. We know that Christine Holloway is last alive in the early morning hours of Sunday, December 1st, 2019, when she is last heard on the 911 call. The defendant wants you to believe that someone else killed her. His lawyer wants you to believe that if you don't believe him, then it must be the PCP that they paid Dr. Frazier the tidy sum of $10,000 to explain to you. But no one took into account his post-homicidal behavior. We know that by 6 a.m., the defendant leaves 6.5 Myrtle Avenue in a car full of bloody stuff that he placed in garbage bags and staged on the deck. Think about that for a second. He carefully goes through all the stuff in the house, separates out the bloody stuff, carefully bags it, stages it on the porch, doesn't get blood on himself in the process, or cleans himself up after going through those steps, before he finishes the tasks in the house before 6 a.m., when the cameras catch him making his run to the education bins. How is he cognitively doing all of this a few short moments after smoking PCP, a drug with an average half-life of 8 hours, a drug that causes cognitive impairment? You know, the cognitive processes that help us plan, prioritize, and sustain efforts towards a goal. Does this behavior sound like a person that is cognitively struggling with planning, prioritizing, in a sustained effort towards reaching a goal? I would suggest to you that his behavior seems very goal-oriented. And let's not leave it there. He climbs into an automobile at 6 a.m. within 4 hours of the last point in time we know Christine Holloway is alive, and he goes on the first of many goal-driven trips that weekend. Don't forget the goal-driven trip to New Haven at 4:30 in the morning on Monday morning in Christine Holloway's car, because his car's running low on gas. As the cash report shows, both phones leave 6.5. They're traveling together to New Haven. Both phones then go dark in New Haven until his suddenly comes back on 2 hours later. He's back in New Haven. Her phone comes back on at some point in time, and it's up in the Naugatuck Forest in close proximity to his nephew's house. Was he getting rid of the phone during that trip to New Haven? Did he explain any other purpose of why he would be going to New Haven at 4:30 in the morning? Does that sound like goal-driven behavior? And then the education bins. On his trip, he navigates the roads out of Myrtle Avenue, out to Elm Street, drives right past the police station, mind you, and doesn't stop. he drives down to a four-way major intersection at the area of Elm, Derby Ave, and Division Street. He successfully navigates that busy intersection. He drives all the way down to St. Michael's Church using cognitive, goal-driven behavior together with working knowledge to reach the bins that he knows are present at that location. Think about that for a second. Think about what it takes to drive a car. Think about all the cognitive functions that it takes to successfully drive a car and why law enforcement officers look to detect cognitively impaired drivers. Driving requires focus, sustained attention, goal destination, adapting to speed, other cars, pedestrians, traffic lights, stop signs. All of this requires cognitive function. And Mr. Morales and his attorney would like you to believe that he is cognitively impaired during this time, but his actions and abilities paint a very different picture. I think the most damning evidence of Mr. Morales' cognitive abilities is at the Shell gas station, 4 hours after Christine Holloway is last heard alive. Watch that tape. Watch how he drives into the gas station, removes the keys from the ignition, climbs out of the car, accelerates his pace towards the door when he cognitively processes the nice man holding the door. He starts skipping forward, accelerates his pace because the door is being held for him. He approaches the register. He effortlessly communicates the brand of cigarettes that he wants. He reaches into his pocket. He locates a debit card. He looks at the card and orientates the magnetic strip. You'll see him. He finds where the magnetic strip is, and he effortlessly swipes it through the card reader. He quickly repositions the card to insert the chip side of the card into the slot when he realizes the magnetic strip isn't working. He follows a series of prompts to navigate through debit and credit choices. He effortlessly enters a PIN number, first once, then a second time. Not fumbling, each is a deliberate keystroke. He would like you to believe that he entered the wrong number. Isn't it equally probable that the card is inactive due to the problems that he's having with his bank? You heard about that on cross-examination. Or even that it's not even his card, perhaps Christine Holloway's card. But nevertheless, undeterred, he reaches into his pocket. He locates and counts out his cash. Doesn't that require cognitive process to do math like that? He has the cognitive ability to realize he doesn't have enough money, and he leaves, and he goes back to the car. He unlocks the car while the fob is still in his pocket. That's tactile. He's feeling. He can locate the buttons on the key fob. He never takes it out. He's not sitting there and pushing the buttons, cognitively sensing the fob and unlocking the car. He gets into the car, keys back in the ignition, not fumbling, not trying to missing it, right into the ignition. And even better then, puts on his seatbelt. Right on, no issues there. Turns his headlights on, yields to a pickup truck that is leaving the gas pumps and pulling up on his left. And then something truly amazing happens. The pickup truck goes out the gas station entrance from Division Street. Mr. Morales realizes that, and instead of following the pickup truck out the wrong way, he navigates. You see him correct his vehicle. He navigates to the right of the little traffic island that has the light pole on it. He navigates to where the station exit is because there is a painted arrow drawn on the ground that shows you where the exit is. And at that point, he yields, not to one car, but to two. And you can see that from the reverse camera shot from the hair salon, where you see the two cars go by him as he is waiting to make a left-hand turn. And off he goes. 4 hours after the last time Christine Holloway is heard alive, and well short of the 8-hour average half-life of PCP. So if it is not PCP, then what is it? The Ansonia police and the state police went through the entire house, multiple times, even taking the sink apart, where they found pieces of Christine Holloway's skull that the defendant had the cognitive ability to grind up during his extensive cleaning efforts. No evidence was collected of any drug usage at 6.5 Myrtle Ave, let alone PCP. There is evidence of an intoxicant, however, and that is beer. Christine Holloway had no drugs or alcohol in her blood tox report. What other evidence exists in this case of alcohol usage? Oh yes, Mr. Morales' statement to you that the PCP hit him like a gallon of vodka. His words, not mine. Sounds like he may have some experience in the area, coupled with his acknowledgement that he had empty bottles of Dubra vodka stashed in the back of his bathroom closet. And how about the text messages? When he tells Christine Holloway early Thanksgiving morning that he went back out after she went to sleep with their sick child, only to tell her at 3:30 in the morning that he went back out and he thinks his mom got him. At 4 a.m. on Thanksgiving morning, Christine Holloway tells him that he's stupid and he needs to stop. He wants you to believe he's a happy family man. These text messages paint a much darker picture. So what happened on December 1st, 2019 at 2 a.m.? Dr. Frazier agreed with me that intoxicants in general, which certainly would include alcohol by their very nature, reduce inhibition, impair judgment, increase confidence, impact mood sometimes wildly, euphoric 1 minute, irritable the next, can produce arguments or negative interactions with others, and can enhance negative feelings and emotions. Mr. Morales' text messages show he has plenty of negative feelings towards Christine Holloway. The only credible evidence in this case of an intoxicant is alcohol. You will have to find Jose Morales credible and believable, since he is the only one who introduces PCP into this case at all. So did he dial 911? Did he wake Christine Holloway up when you hear her in the background quietly whispering, "Stop, who are you talking to? Hang up the phone"? Is she whispering because Vanessa Morales, who has been sick, look at the text messages, doctor's appointments, CVS. The text messages tell us that Vanessa has been sick and neither she nor Christine have been sleeping well. Mr. Morales reminded us as well that Christine was nursing at this point, and she was up during the night nursing. We certainly do not hear any home invasion happening. Do we even hear a TV on that suggests that Christine Holloway is up, as Mr. Morales would like you to believe she was? We hear 1 minute and 14 seconds of quiet whispering of the voices of Christine Holloway and Jose Morales. No home invaders, just a dead woman and a mystery surrounding the disappearance of a 14-month-old, both who were last seen in the presence of Jose Morales. So was Mr. Morales drinking? You don't need an expert to tell you about the effects and duration of alcohol. You may apply your own life experiences. Did she attempt to quiet him near Vanessa's crib because he's been drinking? Did a fight of some sort occur? That's up to you to decide what reasonable inferences that can be drawn from the evidence. But the story doesn't end there. It continues. No calls for help for Christine. No calls for help for the missing child. No parental concerns over the child. You would have to believe, or why would you believe that home invaders who committed murder and kidnapped a child would leave behind a living witness? How does that make sense? Do you believe that they would also stop to take a child safety seat for the child at the scene of a homicide as they're making their getaway car from the car that Mr. Morales says is the real killer's? Does any of that make sense? And what does Mr. Morales do instead of calling the police or calling for help for Christine? He engages in a methodical cleanup over the next 37 hours before he finally leaves 6.5 Myrtle Avenue after Officer Kelly's welfare check at 1 p.m. Monday afternoon. And then he departs. He engages the deadbolt, cognitive processing. He explains he exchanged pleasantries with George O'Mara as he's going out. Not happy with the snow. Yeah, we still got time left, in the winter. He climbs into his car. He drives back to New Haven, where his other children are. No concerns about the naked, dead Christine in the bathtub and his missing child. This is the man that the defense would urge you to find not guilty. The court is going to instruct you with regard to something called consciousness of guilt. Judge Murphy will explain to you it is permissible for the state to show the conduct or statements made by a defendant after the time of an alleged offense that may have been influenced by the criminal act. The conduct or the statements show a guilty conscience. Each and every one of you who are parents, where you have said to your child, who did that, and got the story, therein saw the consciousness of guilt. I believe that you may infer from the evidence of the defendant's actions in cleaning up the scene of the crime, in disposing of evidence from the scene of the crime, in the flight from 6.5 Myrtle Avenue shortly after the welfare check by Officer Kelly on December 2nd of 2019, and his statements to the police about not being present at 6.5 Myrtle the entire weekend were all a direct result of his guilty conscience. Ladies and gentlemen, when you take your juror's oath, it does not require you to leave your life experiences and common sense at the courtroom door. Please do not do that. If you apply your life experiences and common sense to the credible evidence in this case that is available to you, it should satisfy you that the testimony of Jose Morales and the arguments of his lawyer are motivated by their self-interest in your verdict, coupled with denial and shame to Mr. Morales' family and to the greater Ansonia community that has been following this case for 5.5 years. Members of the jury, as I conclude my remarks, I would like to once again thank you on behalf of myself, the members of my office who have assisted me in presenting this case to you, and the people of the state of Connecticut. It is not lost on any of us the imposition this has been on your lives as you step up to make this important decision and to fulfill your role, your important role in civic function. I would simply ask you that as you begin your deliberation, remember the credible evidence in this case indicates that the person who put the hole in the side of Christine Holloway's head is the very same person who within hours later is at that Shell gas station. I would respectfully request a verdict of guilty to the crime of murder and to the crime of tampering with physical evidence, and ask that you bring justice to Ms. Holloway and to her family. Thank you very much. Thank you, Your Honor.
All right, so before we bring our jury in, I just would like to make an announcement. The court is going to be moving into the jury instructions, otherwise known as the jury charge, We do ask for minimal interruptions, so please note the court would request your patience with the charge if you intend to stay. And I would also request your cooperation in not entering and exiting the courtroom unless you absolutely have to. With that, I will instruct the marshals that if someone needs to leave, obviously let them leave. And it is an open courtroom, so if someone wishes to come in, please allow them to come in. The only thing that I would like to avoid is repeated interruptions. Okay, so thank you for that. The next thing that I would like to do is just address counsel relative to the remainder of the proceedings. So after I provide the jury their charge, I'll exclude the jury very briefly. I'll hear any exceptions or comments relative to the charge. I'll also be instructing you at that time to please get together with the clerk. There are many exhibits in this case. Please check the exhibits. I want to make sure that you stipulate on the record that all full exhibits are going in for deliberations and that any exhibits that have not been marked as a full exhibit are not going in to the jury for deliberations. Another thing that I'd like to do before we get that started is I did provide to each one of you a copy of the jury evidence laptop's external DVD guide, which was provided by IT. The jury will be provided with a laptop. It is a clean laptop. It will have the capability to listen to the audio exhibits as well as any DVD video exhibits, and this will provide instructions to the jury. Does anyone have any objection to the court providing that to the jury?
No objection.
Okay. All right. Is there anything further that anyone would like to address?
Nothing from the defense, Your Honor.
All right. So I did go ahead and do two things to the charge generally. I did add the verbiage from the amended information into the specific offenses, and I also did add the Roman numeral 1 and Roman numeral 2 just to identify the counts within these particular charges. Additionally, where we had lesser offenses or lesser included offenses, I did add the word to murder, okay, of murder, so that there was no confusion. I thought that that would provide the best direction to the jurors in trying to move along through these instructions. They are pretty lengthy. All right. Does anyone have any concerns regarding the proposed charge at this point?
Have a mistake, Your Honor.
Okay. With that, I would ask the clerk to please bring our jury in. Welcome back. Counsel, please stipulate to the return of our jurors.
Stipulate.
Thank you. All right, members of the jury, you have heard the evidence presented in this case. I am now going to instruct you as to the law that you are to apply in this case. During these instructions, I will, for the most part, be reading from prepared material. I do this so that I do not inadvertently give you an incorrect instruction. So if I lose eye contact with you from time to time, please bear with me. The reading of these instructions is going to take some time. I'm not sure if I'm going to break or if we're going to try to get through the instructions in all one sitting, okay? So first I'm going to talk to you about the function of the court and the jury. It is exclusively the function of the court to state the rules of law that govern the case with instructions as to how you are to apply them. It is your obligation to accept the law as I stated. What I tell you, not what the attorneys tell you, is the law that you are to follow. If the law, as I give it to you, differs in any way from the claims of law made by counsel, Dismiss from your minds what counsel have said to the extent it differs from what I tell you. You must follow all my instructions and not single out some and ignore others. They are equally important. Also to note, in these instructions, the court does use the terms information and amended information, first count and count 1, second count and count 2, and crimes and offenses interchangeably. You as jurors are the sole judges of the facts. It is your duty to find the facts. You are entitled, in the course of evaluating the evidence, to draw any and all inferences you will find reasonable and logical from the evidence you hear. You are to recollect and weigh the evidence, inform your own conclusions as to what the ultimate facts are. You may not go outside the evidence introduced in court to find the facts. This means that you may not resort to guesswork, conjecture, or suspicion, and you must not be influenced by any personal likes or dislikes, opinions, prejudices, or sympathies. You should not be influenced by my actions during the trial in ruling on motions or objections by counsel, or in comments to counsel, or in questions to witnesses, or in setting forth the law in these instructions. You are not to take my actions as any indication of my opinion as to how you should determine the issues of fact. If I asked any questions of a witness, you must not assume that I hold any opinion on the matter to which my question may relate. Remember that you, as jurors, are at liberty to disregard all comments or questions of the court and the witness's responses to those questions in arriving at your own findings as to the facts. You must not take anything I said or did during the trial as indicating what I think of the evidence or what your verdict should be. Any reference I may make to the evidence is only for the purpose of clarification of some point of law or a point of illustration, or to refresh your recollection as to the general nature of the testimony. I do not intend to emphasize any evidence that I mention or limit your consideration to it. If I do not mention certain evidence, you will use the evidence from your recollection. If my recollection of the evidence does not comport with your recollection, then it is your recollection which must prevail because you are the exclusive trier of the facts. The defendant justly relies upon you to consider carefully his claims, to consider carefully all the evidence, and to find him not guilty if the facts and the law require such a verdict. The defendant rightfully expects fair and just treatment at your hands. At the same time, the state of Connecticut and its people look to you to render a verdict of guilty if the facts and law require such a verdict. The law prohibits the state's attorney or defense counsel from giving personal opinions as to whether the defendant is guilty or not guilty. During my instructions to you, I may repeat certain instructions. I apologize in advance. I do this for the purpose of organization. You are not to consider a repeated instruction more important than any other instruction. All instructions are equally important. Also, in the course of my instructions to you, I may refer you to a previous instruction given. When I do this, I will identify it for you and direct you to the section to which I am referring. Presumption of innocence. In this case, as in all criminal prosecutions, the defendant is presumed to be innocent unless and until proven guilty beyond a reasonable doubt. This presumption of innocence was with this defendant when he was first presented for trial in this case. It continues with him throughout this trial unless and until such time as all evidence produced here in the orderly conduct of the case, considered in the light of these instructions of law and deliberated upon by you in the jury room, satisfies you beyond a reasonable doubt that he is guilty. The presumption of innocence as to each crime charge and as to any lesser included offense as instructed by the court may be overcome only after the state introduces evidence that establishes the defendant's guilt beyond a reasonable doubt. If and when the presumption of innocence has been overcome by evidence proving beyond a reasonable doubt that the accused is guilty of a crime charged or any applicable lesser included offense as instructed by the court, then it is the sworn duty of the jury to enforce the law and to render a guilty verdict. Burden of proof. The state has the burden of proving that the defendant is guilty of the crimes with which he is charged or any lesser included offense as instructed by the court. The defendant does not have to prove his innocence. This means that the state must prove beyond a reasonable doubt each and every element necessary to constitute a crime charge or lesser included offense as instructed. Whether the burden of proof resting upon the state is sustained depends not on the number of witnesses nor on the quantity of the testimony, but on the nature and quality of the testimony. Please bear in mind that one witness's testimony is sufficient to convict if it establishes all the elements of a crime beyond a reasonable doubt. What is reasonable doubt? The meaning of reasonable doubt can be arrived at by emphasizing the word reasonable. It is not a surmise, a guess, or a mere conjecture. It is not a doubt raised by anyone simply for the sake of raising a doubt. It is such a doubt as in serious affairs that concern you, you would heed. That is, such a doubt as would cause reasonable men and women to hesitate to act upon it in matters of importance. It is not hesitation springing from any feelings of pity or sympathy for the accused or any other person who might be affected by your decision. It is, in other words, a real doubt, an honest doubt, a doubt that has its foundation in the evidence or lack of evidence. It is doubt that is honestly entertained and is reasonable in light of the evidence after a fair comparison and careful examination of the entire evidence. Proof beyond a reasonable doubt does not mean proof beyond all doubt. The law does not require absolute certainty on the part of the jury before it returns a verdict of guilty. The law requires that, after hearing all the evidence, if there is something in the evidence or lack of evidence that leaves in your minds as reasonable men and women a reasonable doubt as to the guilt of the accused, then the accused must be given the benefit of that doubt and acquitted. Proof beyond a reasonable doubt is proof that precludes every reasonable hypothesis except guilt and is inconsistent with any other rational conclusion. Evidence. The evidence from which you are to decide what the facts are consists of 1. The sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. 2. The exhibits that have been received into evidence as full exhibits, including pictures, videos, or documents that have been marked as full exhibits. 3. Any facts that the court judicially noticed. And 4. Any stipulations of the parties. In reaching your verdict, you should consider all the testimony and full exhibits admitted into evidence. Certain things are not evidence, and you may not consider them in deciding what the facts are. These include 1. Arguments, statements, and questions by lawyers. The lawyers are not witnesses. What they have said in their closing arguments is intended to help you interpret the evidence, but it is not evidence. If the facts as you remember them differ from the way the lawyers have stated them, your memory of them controls. It is not proper for the attorneys to express their opinions on the ultimate issues in this case or to appeal to your emotions. Also, attorneys have a duty to object when they believe a question is improper under the rules of evidence. You should not be influenced by the objection or by the court's ruling on it, and you are not to hold it against any party for making objections. During the course of trial, you may have heard counsel stand up and make comments about questions made by opposing counsel. You are not to regard any comments that counsel may have made in your deliberations. Any comments about the propriety of questions are not proper for trial or your consideration and should not be used in your deliberations. Lastly, the question the lawyers ask of witnesses are not evidence. It is the testimony of the witnesses in response to the attorney's questions that is evidence. Also not evidence include 2, testimony that has been excluded or stricken. If I have excluded certain testimony, you must follow my instruction to disregard the testimony. In effect, I'm telling you to do what may be difficult, but which you will have to do to best accomplish, and that is to accept in your minds that such stricken testimony is not evidence and must not be considered in your deliberations. Also, some testimony has been admitted for a limited purpose. Whenever I have given a limiting instruction, you must follow it. 3, anything you may have seen or heard when the court was not in session. 4, anything you may have seen or heard from any spectators during the trial. And 5, the document called the amended information, which you will have with you at the time of your deliberations. The information is merely the formal manner of accusing a person of a crime to bring that person to trial. You must not consider the amended information as any evidence of the guilt of the defendant or draw any inference of guilt because he has been charged with crimes. You will note that each count in the amended information contains within it the alleged time, date, and location of the offense. The state does not have to prove the exact time, date, or location of the offense beyond a reasonable doubt. However, the state must prove each element of each offense, including identification of the defendant, beyond a reasonable doubt. Additionally, evidence has been admitted in this case concerning Vanessa Morales and the investigation efforts concerning the location of Vanessa Morales. It is important that you understand that Jose Morales is not on trial for any crime concerning Vanessa Morales, and your deliberations and your verdict as to each count in the amended information is limited to the crimes charged by the state. You are not to concern yourselves with the whereabouts of Vanessa Morales or allow sympathy to play a part in your deliberations as to the two counts in the amended information, murder of Christine Holloway and tampering with physical evidence. The court will provide additional instructions concerning those specific offenses charged by the state further along in this jury charge. I'm going to talk to you about direct and circumstantial evidence. There are generally two kinds of evidence, direct and circumstantial. Direct evidence is testimony by a witness about what that witness personally saw or heard or did. Circumstantial evidence is indirect evidence. That is, evidence from which you could find that another fact exists, even though it has not been proven directly. There is no legal distinction between direct and circumstantial evidence as far as probative value. The law permits you to give equal weight to both, but it is for you to decide how much weight to give any particular evidence. Circumstantial evidence of an event is the testimony of witnesses as to the existence of certain facts or evidence or the happening of other events from which you may logically conclude that the event in question did happen. By way of example, let us assume that it is a December night and you're preparing to retire for the evening. You look out the window and see that it is snowing. You wake up the next morning, come to court, and testify that the night before it was snowing in the area of your house. That is direct evidence of the fact that it snowed the night before. You saw it, and you came into court and testified to that fact. Now assume that it is another December night, the weather is clear, there is no snow on the ground, and you retire for the evening. You wake up the next morning, you look out the window, and you see snow on the ground and footprints across your lawn. You come into court and you testify to those facts. The evidence that the night before there was no snow on the ground and the next morning there was snow on the ground and footprints across your lawn is direct evidence. That direct evidence, however, is circumstantial evidence of the fact that sometime during the night it snowed and that sometime thereafter someone walked across your lawn. The only practical difference between direct and circumstantial evidence is that when you have direct evidence of some fact, the main thing you have to do is determine the believability of the direct testimony given, the credibility of the witness. With circumstantial evidence, you must first determine the credibility of the witness or witnesses and decide whether the facts testified to did exist. Then, you must decide whether the happenings of those events or the existence of those facts leads logically to the conclusion that other events occurred or other facts exist, and ultimately, whether the crimes alleged were committed by the accused. There is no reason to be prejudiced against evidence simply because it is circumstantial evidence. You make decisions based on circumstantial evidence in the everyday affairs of life. There is no reason why decisions based on circumstantial evidence should not be made in the courtroom. In fact, proof of circumstantial evidence may be as conclusive as would be the testimony of witnesses speaking on the basis of their own observation. Circumstantial evidence, therefore, is offered to prove a certain fact from which you are asked to infer the existence of another fact or set of facts. Before you decide that a fact has been proved by circumstantial evidence, you must consider all of the evidence in light of reason, experience, and common sense. Redacted exhibits. There are some exhibits that have been accepted into evidence as redacted versions of the original. These redactions were made by way of agreement by counsel or by order of the court, and you must not speculate as to why the information was redacted or what was redacted. Redacted information is not evidence, and as indicated earlier, you may not go outside the evidence introduced in court to find the facts. This means that you may not resort to guesswork, conjecture, or speculation. Credibility. In deciding what the facts are, you must consider all the evidence. In doing this, you must decide which testimony to believe and which testimony not to believe. You may believe all, none, or any part of any witness's testimony. In making that decision, you may consider a number of factors, including the following. 1, was the witness able to see or hear or know the things about which the witness testified? 2, how well was the witness able to recall and describe those things? 3, what was the witness's manner while testifying? 4, did the witness have an interest in the outcome of this case or any bias or prejudice concerning any party or any matter involved in the case? 5, how reasonable was the witness's testimony considered in light of all the evidence in the case? And 6, was the witness's testimony contradicted by what that witness has said or done at another time, or by the testimony of other witnesses, or by other evidence? If you think that a witness has deliberately testified falsely in some respect, you should carefully consider whether you should rely upon any of that witness's testimony. In deciding whether to believe a witness, keep in mind that people sometimes forget things. You need to consider, therefore, whether a contradiction is an innocent lapse of memory or an intentional falsehood, and that may depend on whether the contradiction has to do with an important fact or with only a small detail. These are some of the factors you may consider in deciding whether to believe testimony. The weight of the evidence presented does not depend on the number of witnesses. It is the quality of the evidence, not the quantity of the evidence, that you must consider. The evidence that Jose Morales was previously convicted of a felony and a misdemeanor larceny is only admissible on the question of the credibility of Jose Morales as a witness, that is, the weight that you will give his testimony. Such evidence is not admissible to prove the guilt of Jose Morales in this case. His criminal record bears only on his credibility. It is your duty to determine whether Jose Morales' testimony is to be believed wholly or partly or not at all. You may consider Jose Morales' prior convictions in weighing his credibility and give such weight to those facts that you decide is fair and reasonable in determining the credibility of Jose Morales. Evidence has been presented that Jose Morales made a statement to the Ansonia police outside of court that is inconsistent with his trial testimony. You should consider this evidence only as it relates to the credibility of his testimony, not as substantive evidence. In other words, consider such evidence as you would any other evidence of inconsistent conduct in determining the weight to be given to the testimony of the witness in court. The law treats an omission in a prior statement as an inconsistent statement. Testimony of police officials. Police officials have testified in this case. You must determine the credibility of police officials in the same way and by the same standards as you would evaluate the testimony of any other witness. The testimony of a police official is entitled to no special or exclusive weight merely because it comes from a police official. You should recall the police official's demeanor on the stand and manner of testifying, and weigh and balance it just as carefully as you would the testimony of any other witness. You should neither believe nor disbelieve the testimony of a police official just because he or she is a police official. I'm going to talk to you about expert testimony. In this case, certain witnesses have taken the stand, given their qualifications, and testified as expert witnesses. A person is qualified to testify as an expert if he or she has special knowledge, skill, experience, training, or education sufficient to qualify him or her as an expert on the subject to which the testimony relates. An expert is permitted not only to testify to facts that he or she personally observed, but also to state an opinion about certain circumstances. This is allowed because an expert from experience, research, and study generally has a particular knowledge of the subject of the inquiry and is more capable than a layperson of drawing conclusions from facts and basing an opinion upon them. An expert witness may state an opinion in response to a hypothetical question. A hypothetical question is one in which the witness is asked to assume that certain facts are true and to give an opinion based on those assumptions. The value of the opinion given by an expert in response to a hypothetical question depends upon the relevance, validity, and completeness of the facts he or she was asked to assume. The weight that you give to the opinion of an expert will depend on whether you find that the facts assumed were proved and whether the facts relied on in reaching the opinion were complete or whether material facts were omitted or not considered. Like all other evidence, an expert's answer to a hypothetical question may be accepted or rejected in whole or in part according to your best judgment. In this case, you were provided expert testimony by the following witnesses: Dr. Eric Frazier, Dr. Kristen Hartnick-McCann, Dr. Michael Hayes, Kristen Medell, Jennifer Nelson, Michael Morganti, and David Carney. Allowing someone to give expert testimony is in no way an endorsement by the court of the testimony or the credentials of the witness. Such testimony is presented to you to assist in your deliberations. No such testimony is binding upon you, and you may disregard the testimony either in whole or in part. It is for you to consider the testimony with the other circumstances in the case, and using your best judgment, determine whether you will give it any weight, and if so, what weight you will give to it. The testimony is entitled to such weight as you find the expert's qualifications in his or her field entitled it to receive, and it must be considered by you, but it is not controlling upon your judgment. You are also to consider his or her general credibility in accordance with the instruction on credibility applicable to all witnesses. Now, in this case, the defendant testified. An accused person, having testified, stands before you just like any other witness. He is entitled to the same considerations and must have his testimony tested and measured by you by the same factors and standards as you would judge the testimony of any other witness. You have no right to disregard the defendant's testimony or to disbelieve the defendant's testimony merely because he is accused of committing multiple crimes. Consider my earlier instructions on the general subject matter of credibility and apply them to the defendant's testimony. I'm going to instruct you now on proximate cause. Proximate cause does not necessarily mean the last act or cause or the act and point in time nearest to the death. The concept of proximate cause incorporates the principle that an accused may be charged with a criminal offense even though his acts were not the immediate cause of the death. An act or omission to act is a proximate cause of the death when it substantially and materially contributes in a natural and continuous sequence, unbroken by an efficient intervening cause to the death. It is a cause without which the death would not have occurred. It is a predominating cause, a substantial factor from which the death follows as a natural, direct, and immediate consequence. Intent. Intent relates to the condition of mind of the person who commits the act, his or her purpose in doing it. Specific intent. Specific intent is the intent to achieve a specific result. A person acts intentionally with respect to a result when his conscious objective is to cause such result. What the defendant intended is a question of fact for you to determine. In this trial, the concept of specific intent applies to the offense of murder at count 1 and tampering with physical evidence at count 2. Recklessness. A person acts recklessly with respect to a result or to a circumstance described by a statute defining an offense when the defendant is aware of and consciously disregards a substantial and unjustifiable risk that such result will occur or that such circumstances exist. The risk must be of such nature and degree that disregarding it constitutes a gross deviation from the standard of conduct that a reasonable person would observe in the situation. the standard of conduct of a reasonable person in the same situation as the defendant is the doing of something that a reasonably prudent person would do under the circumstances, or omitting to do what a reasonably prudent person would not do under the circumstances. A gross deviation is a great or substantial deviation, not just a slight or moderate deviation. There must be a great or substantial difference between, on the one hand, the defendant's conduct in disregarding a substantial and unjustifiable risk, and on the other hand, what a reasonable person would have done under the circumstances. Whether a risk is substantial and unjustifiable is a question of fact for you to determine under all the circumstances. In this trial, the concept of recklessness applies to manslaughter in the first degree, subsection A3, as a lesser included offense, and manslaughter in the second degree as a lesser included offense at count 1. Evidence of intent. What a person's intention was is usually a matter to be determined by inference. No person can testify that he or she looked into another's mind and saw therein a certain knowledge or a certain purpose or intention to do harm to another. Because direct evidence of the defendant's state of mind is rarely available, intent is generally proved by circumstantial evidence. You will refer to my earlier instruction on direct and circumstantial evidence. The only way a jury can ordinarily determine what a person's intention was at any given time is by determining what the person's conduct was and what the circumstances were surrounding that conduct, and from that infer what his or her intention was. To draw such an inference is the proper function of a jury, provided, of course, that the inference drawn complies with the standards for inferences as explained in connection with my instruction on circumstantial evidence. The inference is not a necessary one. You are not required to infer a particular intent from the defendant's conduct or statements, but it is an inference that you may draw if you find it is reasonable and logical. I again remind you that the burden of proving intent beyond a reasonable doubt is on the state. Evidence of motive or the lack of it may also be considered by you in determining the issue of intent. You will refer to my instruction on motive below. Motive. The law does not require that the state in a criminal case prove a motive because it is not an element of the crime. It is not necessary for the state to prove what reason the defendant may have had for committing a crime charged. Because crimes are generally committed for some motive, evidence of a motive may tend to prove the guilt of a defendant. In the same manner, if there appears no adequate motive on the part of the defendant to commit the crime, that may tend to raise a reasonable doubt as to the guilt of the defendant. If the existence of a motive can be reasonably inferred, that may tend to prove the defendant's guilt. If no motive can be inferred, it may or may not raise a reasonable doubt as to the guilt of the defendant. If the absence of a motive does not raise a reasonable doubt that the defendant is guilty, then the fact that the state has not proved what the defendant's motive was does not prevent you from returning a verdict of guilty. I'm going to instruct you on intoxication. There has been some evidence to the effect that the defendant was under the influence of intoxicants, namely PCP and cannabis, at the time of the alleged acts. The statute pertaining to intoxication applies only to the offense of murder at count 1 and the offense of tampering with physical evidence at count 2, and reads in pertinent part as follows. Intoxication shall not be a defense to a criminal charge, but in any prosecution for an offense, evidence of intoxication of the defendant may be offered by the defendant whenever it is relevant to negate an element of the crime charged. Intoxication is defined by statute as a substantial disturbance of mental or physical capacities resulting from the introduction of substances into the body. If you find that the defendant was under the influence of an intoxicant at the time of the alleged acts, you must then determine what effect, if any, this voluntary intoxication had on his ability to form the specific intent required to commit the alleged crimes. Note that intoxication is not a defense to or an excuse for the commission of a crime. It is only relevant to negate an element of the crime charged, such as intent. If you find that the defendant was intoxicated at the time of the crime, you may take this fact into consideration in determining whether he was in such a state of intoxication as to be incapable of forming the required specific intent, which is a necessary element for the commission of the crimes of murder and tampering with physical evidence. If you believe that the defendant, although intoxicated, was still capable of forming a specific criminal intent, then the defendant's responsibility is the same as if he were not intoxicated. You must first decide whether the defendant was intoxicated at the time of the alleged crimes, and second, whether the defendant was incapable of forming an intent to commit the acts constituting the crime of murder at count 1 or the acts constituting the crime of tampering with physical evidence at count 2. Remember, the defendant does not have to prove that he was intoxicated. The state always has the burden of proving beyond a reasonable doubt that the defendant could form the required intent. Any degree of intoxication, not merely total intoxication, may be considered in determining whether the defendant possessed the requisite intent. Consciousness of guilt. In any criminal trial, it is permissible for the state to show that conduct or statements made by a defendant after the time of the alleged offense may have been influenced by the criminal act. That is, the conduct or statements show a consciousness of guilt. For example, flight, when unexplained, may indicate consciousness of guilt if the facts and circumstances support it. Such acts do not, however, raise a presumption of guilt. If you find the evidence proved and also find that the acts were influenced by the criminal act and not by any other reason, you may, but are not required to, infer from this evidence that the defendant was acting from a guilty conscience. The state claims that the following conduct is evidence of consciousness of guilt: the defendant's actions in cleaning up the scene of the crime, the defendant's actions in disposing of evidence from the scene of the crime, the defendant's flight from 6.5 Myrtle Avenue shortly after the welfare check by the Ansonia Police Department on December 2nd, 2019, and the defendant's statements to the police about not being present at 6.5 Myrtle Avenue the weekend of the incident. It is up to you as judges of the facts to decide whether the defendant's acts, if proved, reflect a consciousness of guilt and to consider such in your deliberations in conformity with these instructions. Identity of the defendant. The state has the burden to not only prove every element of a crime, but also the identity of the defendant as the perpetrator of the crime. You must be satisfied beyond a reasonable doubt of the identity of the defendant as the one who committed the crime, or you must find the defendant not guilty. If you have a reasonable doubt as to the accuracy of identification, you must find the defendant not guilty. Third-party culpability. There has been evidence that a third party, an unknown individual, not the defendant, committed the crime of murder of Christine Holloway, with which the defendant is charged. This evidence is not intended to prove the guilt of the third party, but is a part of the total evidence for you to consider. The burden remains on the state to prove each and every element of the offense beyond a reasonable doubt. It is up to you and to you alone to determine whether any of this evidence, if believed, tends to directly connect a third party to the crime with which the defendant is charged. If, after full and fair consideration and comparison of all the evidence, you have left in your minds a reasonable doubt indicating that the alleged third party, in this case an unknown individual, may be responsible for the crime the defendant is charged with, committing the murder of Christine Holloway, then it would be your duty to render a verdict of not guilty as to the accused, Jose Morales, at count 1. Specific charges brought by the state. I will now turn to the specific offenses charged in this case. The amended information in this case contains 2 counts against the defendant. In other words, the state charges the defendant with committing 2 separate offenses or crimes. You are to consider only the specific charges submitted to you and not concern yourself with how the information may have been read when it was read to you at the start of trial. Please note you will also be instructed to consider lesser included offenses under count 1 if applicable. Additional instructions on your consideration of lesser included offenses will be provided further along in this charge. The defendant is entitled to and must be given by you a separate and independent determination of whether he is guilty or not guilty as to each crime charged in each count, including lesser included offenses if applicable, in accordance with the instructions to follow. Each of the 2 counts charged in the amended information, including lesser included offenses at count 1 if applicable, set forth a separate and distinct crime. The state is required to prove each element of each crime charged in each count, including any lesser offenses instructed, to be deliberated upon at count 1 beyond a reasonable doubt. Each crime charged under each count, including any lesser included offenses where applicable, must be deliberated upon separately. Please note, the total number of counts charged in an information does not add to the strength of the state's case. You may find that some evidence applies to more than one count in the amended information or more than one crime under a count. The evidence, however, must be considered separately as to each element of each crime deliberated upon. Each count is a separate entity. You must consider each count separately, including lesser included offenses, if applicable, as instructed, and return a separate verdict for each count. This means that you may reach opposite verdicts on the two different counts. A decision on one count does not bind your decision on the other count. I have previously instructed you and herein reiterate that the amended information is not evidence. It is merely a paper statement of charges against the defendant upon which the state proceeds to trial. You must not consider it as any evidence of the guilt of the defendant or draw any inference of guilt of the defendant from the amended information.
Will the court consider a quick break?
Certainly. All right, so we are going to go into the specific charges next, so this is a good time to break. We're just a little over halfway done, so we're going to take a brief recess. Ladies and gentlemen of the jury, before I move on to the two counts of the information, I want to redirect your attention back to the instruction that I gave on third-party culpability. I inadvertently left out lesser included offensive, if applicable, in the last sentence of that particular charge. So in that subheading, which you will have a copy of these instructions, you will have the correct terminology, but I want to correct it on the record as well. So I'm going to reread that last sentence under third-party culpability. If after full and fair consideration and comparison of all the evidence, you have left in your minds a reasonable doubt indicating that the alleged third party, in this case an unknown individual, may be responsible for the crime the defendant is charged with committing, the murder of Christine Holloway, or any lesser included offenses, if applicable, then it would be your duty to render a verdict of not guilty as to the accused, Jose Morales, at count 1, okay? So that included the correction. And now I'm going to bring you back to the specific offenses in this case. First count, murder, Connecticut General Statute, Section 53A-54A. The defendant is charged in the first count of the amended information with the murder of Christine Holloway in violation of Connecticut General Statutes, Section 53A-54A. The state charges in the first count that in the county of New Haven in the city of Ansonia on or about Sunday, December 1, 2019, between approximately 1:57 a.m. and approximately 6 a.m. at 6.5 Myrtle Avenue within said city. The said Jose Morales, with intent to cause the death of Christine Holloway, did strike Christine Holloway multiple times in the head and torso with an instrument that created several round-shaped marks that measured approximately 1 inch in diameter, severely fracturing her skull and causing other blunt force injuries, which resulted in her death. The statute defining the offense of murder reads in pertinent part as follows. A person is guilty of murder when, with intent to cause the death of another person, he causes the death of such person. For you to find the defendant guilty of this charge, the state must prove the following elements beyond a reasonable doubt. Element 1, intent to cause death. The first element is that the defendant specifically intended to cause the death of Christine Holloway. There is no particular length of time necessary for the defendant to have formed the specific intent to kill Christine Holloway. A person acts intentionally with respect to a result when his conscious objective is to cause such result. Murder is a specific intent crime. You will refer to my earlier instructions on specific intent. The intent to cause death may be inferred from circumstantial evidence. You will refer to my earlier instruction on direct and circumstantial evidence. The type and number of wounds inflicted, as well as the instrument used, may be considered as evidence of the perpetrator's intent, and from such evidence, an inference may be drawn that there was an intent to cause death. Any inference that may be drawn from the nature of the instrumentality used and the manner of its use is an inference of fact to be drawn by you upon consideration of these and other circumstances in the case in accordance with my previous instructions. Such inferences are not necessary, but they are inferences you may draw if you find they are reasonable and logical and in accordance with my instructions on circumstantial evidence. Declarations and conduct of the accused before or after the infliction of wounds may be considered if you find they tend to show the defendant's intent. This inference is not a necessary one, that is, you are not required to infer intent from the defendant's alleged conduct, but it is an inference you may draw if you find it is reasonable and logical and in accordance with my instructions on circumstantial evidence. Element 2, caused death. The second element is that the defendant, acting with the intent to cause the death of Christine Holloway, caused the death of Christine Holloway. This means that the defendant's conduct was the proximate cause of Christine Holloway's death. You must find it proved beyond a reasonable doubt that Christine Holloway died as a result of the actions of the defendant. You will refer to my earlier instruction on proximate cause. In summary, for the crime of murder, the state must prove beyond a reasonable doubt that 1, the defendant intended to cause the death of Christine Holloway, and 2, in accordance with that intent, the defendant caused the death of Christine Holloway. If you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of murder, then you shall find the defendant guilty of murder in violation of Connecticut General Statutes, Section 53A-54A at the first count, and you shall then next consider the charge of tampering with physical evidence at the second count. You will not consider the lesser included offenses below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of murder, you shall find the defendant not guilty of the crime of murder and shall then move on to consider the lesser included offense of manslaughter in the first degree. But again, you will consider lesser included offenses if and only if you unanimously find that the defendant is not guilty of murder. Lesser included offenses to murder. In accordance with the court's previous instructions, you will consider lesser included offenses if and only if you unanimously find that the state has not proved beyond a reasonable doubt all the elements of the crime of murder. If you find the defendant guilty of murder, you shall not consider the lesser included offenses in this subsection and instead shall move on to consider the charge of tampering with physical evidence at the second count. The defendant at the first count of the amended information is specifically charged with the crime of murder. The offense of murder under our penal code is such that it may include the elements of the crimes of manslaughter in the first degree and manslaughter in the second degree. This brings into play the rule of law known as lesser included offenses. You will consider lesser included offenses in the order and under the circumstances prescribed herein. The fact that I am instructing you on lesser included offenses should not be interpreted by you that I believe the evidence proves the accused guilty of any lesser included offense. You, the jury, are the sole judges of the facts in this case. You must determine whether the defendant is guilty beyond a reasonable doubt of murder in count 1 or is guilty of any respective lesser included offense. If you unanimously find that the state did not prove beyond a reasonable doubt all the elements of the crime of murder and that the defendant, therefore, is not guilty of murder, you shall then and only then next consider the lesser offense of manslaughter in the first degree, Connecticut General Statutes, Section 53A-55, subsection A, subsection 3, directly below. A, manslaughter in the first degree, Connecticut General Statutes, Section 53A-55, subsection A, subsection 3. The statute defining this offense reads in pertinent part as follows. A person is guilty of manslaughter in the first degree when under circumstances evincing an extreme indifference to human life, he recklessly engages in conduct which creates a grave risk of death to another person and thereby causes the death of another person. For the defendant to be found guilty of this charge, the state must prove the following elements beyond a reasonable doubt. Element 1, conduct creating a grave risk of death. The first element is that the defendant engaged in conduct that created a grave risk of death. Element 2, recklessness. The second element is that the defendant acted recklessly. A person acts recklessly with respect to a result or circumstances when he is aware of and consciously disregards a substantial and unjustifiable risk that such result will occur or that such circumstances exist. You will refer to my earlier instruction on recklessness. And element 3, extreme indifference to human life. The third element is that the defendant's conduct demonstrated an extreme indifference to human life. Indifference means simply not caring. It means lacking any interest in a matter one way or the other. Extreme means existing in the highest or greatest possible degree. Extreme indifference is more than ordinary indifference. It is synonymous with excessive and is the greatest departure from the ordinary. What evinces an extreme indifference to human life is a question of fact. And element 4, caused death. The fourth element is that the defendant's conduct caused the death of Christine Holloway. This means that the defendant's conduct was the proximate cause of the decedent's death. You will refer to my earlier instruction on proximate cause. You must find it proved beyond a reasonable doubt that Christine Holloway died as a result of the actions of the defendant. So in summary, the state must prove beyond a reasonable doubt that 1, the defendant engaged in conduct that created a grave risk of death. 2, the defendant acted recklessly. 3, the defendant acted under circumstances evincing an extreme indifference to human life. And 4, the defendant caused the death of Christine Holloway. If you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of manslaughter in the first degree, pursuant to Connecticut General Statute Section 53A-55, subsection A, subsection 3, then you shall find the defendant guilty of manslaughter in the first degree in violation of Connecticut General Statute Section 53A-55A3 at the first count. You shall not consider any additional lesser included offenses and instead shall move on to deliberate on count 2 of the amended information, skipping directly to the court's instruction below entitled Second Count, Tampering with Physical Evidence. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of manslaughter in the first degree, Connecticut General Statute Section 53A-55A3, you shall find the defendant not guilty of manslaughter in the first degree, Connecticut General Statute Section 53A-55A3, and you shall then and only then consider the lesser offense of manslaughter in the second degree, Connecticut General Statute Section 53A-56A1 directly below. B, manslaughter in the second degree, Connecticut General Statute Section 53A-56A1. The statute defining manslaughter in the second degree reads in pertinent part as follows. A person is guilty of manslaughter in the second degree when he recklessly causes the death of another person. For you to find the defendant guilty of this charge, the state must prove the following elements beyond a reasonable doubt. Element 1, caused death. The first element is that the defendant caused the death of Christine Holloway. This means that the defendant's conduct was the proximate cause of Christine Holloway's death. You will refer to my earlier instruction on proximate cause. You must find it proved beyond a reasonable doubt that Christine Holloway died as a result of the actions of the defendant. Element 2, recklessness. The second element is that the defendant's actions that resulted in the death of Christine Holloway were reckless. A person acts recklessly with respect to a result or circumstances when he is aware of and consciously disregards a substantial and unjustifiable risk that such result will occur or that such circumstances exist. You will refer to my earlier instruction on recklessness. So in summary, the state must prove beyond a reasonable doubt that 1, the defendant caused the death of Christine Holloway, and 2, the defendant's actions that resulted in her death were reckless. If you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of manslaughter in the second degree, pursuant to Connecticut General Statute Section 53A-56A1, then you shall find the defendant guilty of manslaughter in the second degree in violation of Connecticut General Statute 53A-56A1 at the first count and deliberate on the second count. However, if you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of the crime of manslaughter in the second degree, Connecticut General Statute Section 53A-56A1, you shall find the defendant not guilty of manslaughter in the second degree at the first count and deliberate on the second count. Roman numeral 2, second count. Tampering with physical evidence in violation of Connecticut General Statutes Section 53A-155. The defendant is charged in the second count of the amended information with tampering with physical evidence. The state charges in the second count that in the county of New Haven in the city of Ansonia, on or about Sunday, December 1, 2019, at approximately 2 a.m. until approximately 1:30 p.m. on Monday, December 2nd, 2019, at 6.5 Myrtle Avenue within said city, the said Jose Morales, believing that a criminal investigation conducted by a law enforcement agency is about to be instituted, the said Jose Morales did destroy and conceal and remove physical evidence of the crime of murder with the purpose to impair its availability in such criminal investigation. The statute defining this offense reads in pertinent part as follows. A person is guilty of tampering with physical evidence if, believing that a criminal investigation conducted by a law enforcement agency is about to be instituted, he destroys, conceals, or removes any record, document, or thing with purpose to impair its verity or availability in such criminal investigation. For you to find the defendant guilty of this charge, the state must prove the following elements beyond a reasonable doubt. Element 1, criminal investigation. The first element is that the defendant believed that a criminal investigation conducted by a law enforcement agency was about to be instituted. It does not matter whether the investigation was pending or not, as long as the defendant believed that it was. Element 2, tampering. The second element is that the defendant tampered with physical evidence. Physical evidence means any article, object, document, record, or other item of physical substance that is or is about to be produced or used as evidence in an official proceeding. Element 3, intent to deceive. The third element is that the defendant destroyed, concealed, or removed any physical evidence with the purpose of impairing its verity or availability in such proceeding. The defendant must have acted with the specific purpose or intent of impairing the verity or availability of the evidence. A person acts with specific intent when his conscious objective is to cause such result. You will refer to my previous instruction on specific intent. In summary, the state must prove beyond a reasonable doubt that the defendant believed that a criminal investigation conducted by a law enforcement agency was pending or about to be instituted, tampered with physical evidence, and 3, specifically intended to impair the availability of the evidence in the criminal investigation. If you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of tampering with physical evidence, then you shall find the defendant guilty of tampering with physical evidence in violation of Connecticut General Statute, Section 53A-155 at the second count. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of the crime of tampering with physical evidence, you shall then find the defendant not guilty of tampering with physical evidence at the second count. In deciding whether the defendant is guilty or not guilty, you should not concern yourselves with the punishment or potential consequence in the event of a conviction. This is a matter exclusively within the court's function under the limitations and restrictions imposed by statute. You are to find the defendant guilty or not guilty, uninfluenced by the possible punishment or consequence that may follow conviction. You should not be influenced by any sympathy for the defendant, the defendant's family, the decedent, the decedent's family, or for any other person who might in any way be affected by your decision. As I indicated earlier, your verdict must be based on the evidence introduced in court and my instructions on the law. Our system of justice depends on judges like me and jurors like you making careful, unbiased, and fair decisions. During our interactions with other people, it is not unusual for us to group or categorize people. Sometimes these categorizations involve negative or positive biases or prejudices, which may be conscious or unconscious. Such preferences or biases, whether they are conscious or unconscious, have no place in a courtroom or your deliberations, where our goal is to treat all parties equally and to arrive at a just, fair, and unbiased verdict. All people deserve fair treatment in our system of justice, regardless of their race, national origin, religion, age, disability, gender identity, sexual orientation, education, income level, or any other personal characteristic. Techniques that you can use as jurors to check whether any unconscious biases are influencing you include slowing down and examining your thought processes thoroughly to identify where you may be relying on reflexive gut reactions and to consider whether you are making assumptions that have no basis in the evidence. Ask yourself whether you would view the evidence differently if the parties, witnesses, or attorneys had different personal characteristics. In sum, your task is to render a verdict based on facts drawn only from the evidence introduced in the courtroom and from the law as stated in my instructions to you, and not based on prejudice or bias for or against any party or person involved in the trial. In conclusion, I impress upon you that you are duty-bound as jurors to determine the facts based on the evidence as it has been presented, to apply the law as I have outlined it, and then to render a verdict of guilty or not guilty as to each count. When you reach a verdict, it must be unanimous. That is, all 12 of you must agree on the verdict. As a check that your verdict is in fact unanimous, the clerk may ask each of you to individually announce your verdict in court. It is the duty of each juror to discuss and consider the opinions of the other jurors. Each of you takes into the jury room your individual experience and wisdom. Your task is to pool that experience and wisdom. You do that by giving your views and listening to the views of others. There must necessarily be discussion and give and take within the scope of your oath. That is the way in which a unanimous verdict is reached. Despite that, in the last analysis, it is your individual duty to make up your own mind and to decide this case upon the basis of your own individual judgment and conscience. Now, if you took notes during the evidence, you may use them during deliberations and you may discuss your notes with fellow jurors. Remember, notes are merely aids to your memory and should not be given precedence over your independent recollection of the evidence. If there is a conflict between your recollection and your notes or the notes of any other juror, it is your recollection of the evidence that must prevail. Your notes or the notes of any other juror are not evidence. You will recall my earlier definition of what constitutes evidence. Your verdict must be based exclusively on evidence presented at trial and the principles of law given to you in these final instructions. A juror who has not taken notes should rely on his or her recollection of the evidence and should not be influenced by the fact that other jurors have taken notes. Notes are only a tool and are not always accurate. Do not assume that a voluminous note taker has taken notes that are necessarily more accurate than your memory. You may discuss your notes with your fellow jurors during the deliberations phase. The decision to do so is yours and yours alone. After the trial is concluded, all notes will be collected by the court staff and destroyed. I remind you that you have the right to request portions of the testimony to be read back to you if you deem it essential during your deliberations. You will have all the admitted exhibits with you during your deliberations. You may only deliberate when all 12 of you are present in the jury deliberation room. Inform the judicial marshal or court officer when you have reached a verdict, but do not tell him or her your verdict. You will be asked to return to the courtroom where your foreperson will announce the verdict orally in response to questions from the courtroom clerk. The rest of the panel will be asked whether they concur with the verdict. If you have any questions, please send them out as a note signed by the foreperson marked with the time, and please be as specific as possible. You will have the full exhibits with you during your deliberations. We will also send in with you a computer on which you will be able to view or hear the CD, DVD evidence. You will also have with you in the jury room a copy of these instructions, which will be marked as a court exhibit. I remind you, however, that you should follow all the court's instructions and not single out some and ignore others. They are all equally important. Do not begin deliberations until you have selected one of your members to be the foreperson of the jury, and you have received a copy of the court's jury charge, the amended information, the device, instructions on how to access the device, and all fully admitted exhibits. So, ladies and gentlemen, at this point in time, I am going to ask all of you to return to the deliberations room. You are not able to deliberate at this point in time. I'm going to ask you to not begin your deliberations. I have to take comments on the record, and then I will bring you out here for one final moment before I send you back in to conduct your deliberations. So please, no discussing the case with one another just yet. Madam Clerk.
To the presence of the jury, Your Honor.
Thank you. All right, ladies and gentlemen of the jury, it is at this point that I'm going to excuse the regular jurors to the deliberations room. I am going to ask the one alternate juror to please remain in the courtroom. I will provide additional instructions. You are in a position where you can begin your deliberations in accordance with my instructions, which means that once you get back into the deliberations room, you are not to start deliberating until you have selected a foreperson and until you have received all the items that I indicated that you needed to have with you, which include the full exhibits, the jury charge, which has been marked as a court exhibit, the amended information, which has also been marked as a court exhibit, the computer device and attachments, instructions on how to access the computer device, which has also been marked as a court exhibit. So once you have all of those things and you've selected a foreperson, you may begin your deliberations. I do intend to wrap up court today at 4:30, but I would ask that you deliberate in the meantime for however much time that there is left between now and 4:30. So if all regular jurors would please stand, with the alternate juror to please remain seated. Thank you, and if you wouldn't mind going to the deliberations room. May I just get your initials? Yes. Okay, I just want to make sure I have the right juror behind. Thank you. So it is